بسم الله الرحمن الرحيم الحمد لله رب العالمين وصلى الله وسلم وبارك على نبينا محمد النبي الكريم وعلى آله وأصحابه وسلم تسليما كثيرا. اللهم فقهنا في الدين وعلمنا التأويل وألهمنا رشدنا يا رب العالمين. Alhamdulillah. Today we're looking at three sections that complete our look at the fiqh of mu'amalat. The first is Kitabul Ma'dhun. And in Arab, al-Ma'dhun, al-Idhn, now the author, the commentator tells us, وَلُغَةً al-i'lam. But what is al-i'lam? Idhn is i'lam. Right? Right? Al-Ma'dhun is from maddat al-Idhn. Right? Right? So هو أي الإذن لغة الإعلام وشرعا فك الحجر وإسقاط الحق. Right? So a servant, a slave, may have permission to transact or may have non-permission to transact. So, right? So there's hajr, right? And the idhn can be am or it can be muqayyad, right? So, because what's the consideration? That the abd, al-abdu ma yamlikuhu li sayyidihi. So, if this abd can go and transact and buy and sell, then he may do things that are outside the interest of the sayyid. He explains, قال رحمه الله تعالى إذا أذن المولى لعبده في التجارة إذنا عاما جاز تصرفه في سائر التجارات يشتري ويبيع ويرهن ويسترهن, right? يعني في كل ما كان من صنيع التجار, of all the things that are allowed for traders, right? So if the general permission is given by the master to his slave in tijara, in trade, if the idhn am, then all that is related, then he can engage in all types of commercial transactions, buying and selling and giving rahan and taking rahan, etc. وإذا أذن له في نوع منها دون غيره فهو مأذون في جميعها. Right? And if the master gives permission for one type of trade and not others, then they have permission in all types of transactions. Right? Right? In that you have hajr and you have idhn in transaction. But we'll see some detail to this, right? So he mentions, وَإِنْ أَذِنَ لَهُ فِي شَيْءٍ بِعَيْنِهِ. He's not ma'dhun, but this is the idhn al-khas, right? Right? He says, you can go buy and sell this, right? So they're still in a state of prevention from transaction. You can't go buy and sell, but you can sell this, buy this, do this, right? Then this is not ma'dhun, right? Rather, but they are serving. Right? Right? As وإقرار المأذون بالديون والغصوب جائز. Right? Why? Because so the asl and al-abd lil-istikhdam. Right? The basis is that the slave is used for service. Right? So when they're whereas idhn, that you can buy and sell. Right? So they're given now the ikhtiyar of buying and selling. But then but they're not serving you now, right? They're trading themselves. The iqrar al-ma'dhun, the one who granted permission of transaction, they're admitting to debts or to misappropriation is valid. Right? Because this is from what's entailed by tijara, by trade. وَلَيْسَ لَهُ أَنْ يَتَزَوَّجْ. Right? But the Abd al-Ma'dhun, cannot marry because it's not trade. إِلَّا أَنْ يُزَوِّجَ مَمَالِيكَهُ, unless he marries. عفوا ولا that's why I was confused, sorry. ولا أن يزوج مماليكه, nor to marry off those that are under his ownership, right? Under his dependent ownership. Why? Because though he has permission to transact, because they belong to the master, right? And this is the position of Abu Hanifa and Imam Muhammad, as mentioned in the Tasheeh al-Quduri. وَلَا يُكَاتِب, right? وَلَا يَعْتِقْ عَلَى مَال, and he cannot enter into aqd of kitaba with a كَاتَبَهُ عَلى مَال, that's okay, to enter into an agreement with a slave that if you give this much, you're free. وَلَا يَعْتِقْ عَلى مَال, right? Nor to free in exchange for money. Right? So one, the kitaba that you agree in writing, right? That if you pay me this much, you will be freed. عِتْقَ عَلَى مَال is okay. Give me this, I will free you. So he gives him. And وَلَا يَهَبْ, and of course, and just freeing the slave. So Abd al-Ma'dhun cannot enter into aqd kitaba nor into itq ala mal, and a fortiori can't free the abid that are under him. وَلَا يَهَبُ بِعِوَضٍ وَلَا بِغَيْرِ عِوَضٍ, and they cannot give gifts whether in exchange for something or without exchange. Right? So this doesn't enter into the idhn bit-tijara. إِلَّا أَن يُهْدِيَ الْيَسِيرِ مِنَ الطَّعَامِ أَوْ يُضِيفَ مَنْ يُطْعِمُهُ. Right? Unless they gift a little of food, or they host those who have fed them. Because this is from what tujar do. Right? Right? Because this is, right? 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 And it's أو يضيف من يطعمه, this is not a condition. Right? Al-Kuhustani is quoted, وَكَذَا مَنْ لَمْ يُطْعِمْهُ, and also those who haven't fed you. Right? And the asl is أن له أن يفعل كل ما كان متعارفا من تصرفات التجار. He can do that which is from the regular practices of traders. وَدُيُونُهُ مُعَلَّقَةٌ بِرَقَبَتِهِ. But now, the abd, if they trade and they take on debts, their debts are upon them. How? يُبَاعُ لِلْغُرَمَاء. If the debts accumulate, he's not able to pay, he would be sold لِلْغُرَمَاءِ أي لِأَجْلِهِمْ, on behalf of the debtors, to clear the debt. So this is the risk that the owner takes. Now the owner could just pay off the debts himself. He's going to trust this abd, so he's lets him trade. He got in debt, he can choose to relieve him. Said, don't worry, I'll pay off your debts. But he can't. And the debtors say, no, we insist on payment. Then the slave, if the owner refuses to pay as well, he doesn't have to. He said, sell him. So they sell him to pay those debts. Right? إِلَّا أَنْ يَفْدِيَهُ الْمَوْلَى, unless the owner salvages them. Right? Means pays the debts on his behalf. وَيُقْسَمُ ثَمَنُهُ بَيْنَهُم, and the price of sale would be divided amongst them. بالحصص, according to their share of the debts. فإن فضل من ديونه شيء طولب به بعد الحرية. But if more debt remains after selling him, then that remains owed by the slave once the slave is freed. Because the slave is sold, they're not freed, like they're sold. So the slave is owned by Khalid. Slave was given permission to transact, took on $100,000 of debt, could not repay it. Debtors demanded repayment, came to the owner. Bilal, that's it. Let's sell him. Only got $75,000 for him. Right? Sold him to Amir. But he's still a slave. But it remains on the record that he owes $25,000. When he does become free, it is demanded from him. That's the challenge, right? وإن حجر عليه لم يصر محجورا عليه حتى يظهر حجره حتى يظهر حجره بين أهل سوقه. If the owner, if the slave is مأذون, and then the owner makes hajr of him, prevents him from transaction, they're not deemed mahjur, prevented from transaction, until this is known to the people of the market. Because what they know is that he can transact. Right? So they're allowed to go with this asl until it's clear that he no longer has the right of transacting. فإن مات المولى أو جن أو لحق بدار الحرب مرتدا والعياذ بالله صار المأذون محجورا عليه. So if the servant had permission of transacting, but his owner, who'd given him the permission, dies or loses his sanity or abandons the lands of the Muslims and disappears into enemy lands, having apostated, وَالْعِيَاذُ بِاللَّهِ, then the idhn goes, right? Because it's contingent upon the rida of the owner, and the owner's rida is no longer available, right? وإذا أبق العبد أي المأذون صار محجورا. If a servant who has permission of transacting flees from their owner, they become mahjur, they no longer have the right of transacting. وإذا حجر عليه فإقراره جائز فيما في يده من المال. If hajr is done on the abd who is ma'zoon by his own admission, then his own admission is valid with respect to what he has of wealth in his hands, because that's traces of what he had already done. عند أبي حنيفة. Right? So if he has some money and he said, well, I stole this money is amana belonging to so and so, etc., then that would count. وإذا لزمته ديون تحيط بماله ورقبته لم يملك المولى ما في يده. If the slave who has permission of transacting has upon them debts that encompass all the wealth that the slave has on hand, plus his own value, then what is in the hands of that Abd al-Ma'dhoon is not ascribed to the master. Why? Because the rights of the debtors is given precedence. فإن أعتق أي المولى عبيده لم يعتقوا عنده. لم يعتقوا عند أبي حنيفة. So in this case, if you're the abd who has been given permission to transact, he's in so much debt that it encompasses all his wealth and his own value, and the debtors are demanding, and he's ajiz from fulfilling their debt, then in this case, unless the owner says, I'll clear the debts, right? The debtors have more right to the wealth and to the slave than he does, so he can't free for example, the slaves under the ma'dhun's hands. According to Abu Hanifa, وَقَالَ يَمْلِكْ مَا فِي يَدِهِ. But the Sahibain said that the owner still ultimately owns what's in the hands of the Abd al-Ma'dhun. وإذا باع المولى وإذا باع من المولى شيئا بمثل قيمته جاز فإن باعه بنقصان لم يجوز. In this case, where the slave is in major debt, right? Yeah, as described, then if the slave sells something to the master by its market value, market price, the qima or more, it's valid. Why? Because it's not considered a questionable transaction. فَإِنْ بَاعَهُ بِنُقْصَانٍ لَمْ يَجُوز. But if he sells it for less than that, it would not be valid. Because what would be the trick? Slave, Abd al-Ma'dhun gets into major debt. Says, okay, just sell the things to me. Don't give them to me. Just sell them to me. So he sells him 10 slaves for $10. So I didn't give them to the owner, I sold them. I'm allowed to do tijara. No, because what's happening there? The rights of the debtors is taken. وإن باعه المولى شيئا بمثل القيمة. But if the owner sells the Abd al-Ma'dhun something for market value or less, the transaction is valid. فإن سلمه إليه قبل قبض الثمن بطل الثمن. But if the master gives the item of sale to the Ma'dhun before taking the price, the price no longer becomes binding. Why? لأنه بالتسليم بطلت يد المولى في العين. Right? Because the master does not owe his slaves anything. وإن أمسكه في يده حتى يستوفي الثمن جاز. But if the owner holds onto the item of sale until his Abd Ma'dhun pays the price, this is valid. وإن أعتق المولى المأذون وعليه دين فعتقه جائز. Now, separate issue, in my copy it should be in a fresh paragraph. If the master frees, makes itq, emancipates his slave who's ma'dhun, but this Abd Ma'dhun has debts upon them, but it's not in the former case. There's a distinction, right? If you pay attention, then this itq is valid, then this emancipation is valid. وَالْمَوْلَى ضَامٍ لِقِيمَتِهِ لِلْغُرَمَاء. But the owner must compensate his value to the extent of his value to the debtors, right? Because they have a right over that. وَمَا بَقِيَ مِنَ الدِّيُونِ يُطَالَبُ بِهِ الْمُعْتَقِ. And if debts remain beyond that, beyond the qima, those are demanded from the slave who was freed, the Abd al-Ma'dhun who was freed. وَإِذَا وَلَدَتْ الْمَأْذُونَةُ مِنْ مَوْلَاهَا فَذَلِكَ حَجْرٌ عَلَيْهَا. If a female slave who was ma'dhun, who had permission of transacting, gives birth from her master, then that is a hajr, prevention of transaction, because now she is walad, right? Because لأن الظاهر أنه يحصنها بعد الولادة, because the apparent is that he would protect her after she gave birth to his child. Right? And this is one of the ways to integrate people who'd been captured into Muslim societies, right? That, so the walad, because the default, so people problematize this, and it's a different society. We're past the time of this, but, in societies where there's war, prisoners there's two things. Men would be imprisoned, but women would be raped, murdered, this and that. Here, those captives, there's fiqh, there's law and limits related to how they're dealt with, right? So they wouldn't languish in prison and be tortured or anything, but rather they're integrated into society, right? And it's not a free-for-all, right? Like people don't say, well, the milk al-yamin, right? There's istibra, that you can't just, it's not just like a situation where they have relations with different people. There's istibra. That relationship is similar to marriage in many ways. In that, if someone has relations with them, no one else, other than the owner, can other people have relations with them? No, unless there is marriage, and between relations there's istibra. There is a waiting period, akin to idda, as we see in the ahkam of istibra. But then, if they have relations with them, the default is that they would have a child. Once they have a child, this becomes the mother of the person's child. The child of the slave woman from the free man would be free. The mother becomes walad. Upon the death of of her master, what would happen to her? She would be free. But not only that, frequently they would be freed because she's the mother of the child. Even if she doesn't legally become free at that time, she's treated as a wife is treated, right? And this way, rather than people's lives being ruined, either they're being imprisoned or tortured or raped, etc., this is a way that they are incorporated into society and dignified. Now, is it an ideal scenario? No, it's not. But this is how it was, and we have to understand it as it was, right? And not sensationalize it in other ways, right? وإذا أذن ولي الصبي للصبي في التجارة فهو في الشراء والبيع كالعبد المأذون إذا كان يعقل البيع والشراء. If the guardian, the wali of a child, right? And there's the order that's mentioned in the commentary, right? It will be the father, then the wasi, the one mentioned in the will to be the guardian, then the grandfather, then the one selected by the grandfather, then the qadi, and then we'll see. And we've seen it in the section on personal law. To be familiar with it. Gives permission to the child to trade, then this permission, right, relates to buying and selling, just like the Abd al-Ma'dhoon, if they are able to buy and sell. Right? And this is, the sabi, of course, is meant the mumayyiz. Right? And then we have Kitab al-Muzara'a. Right? So he says, rahimahullah ta'ala, قال المزارعة, right? Now muzara'a is a general name. Muzara'a, you'd say, well, muzara'a is from zira'a, which is, what's zira'a? Just farming. But muzara'a is not just farming. And muzara'a is a technical term. Right? It has other names, mukhabara, muhaqala, right? And in the Sharia, it has a particular sense. Muzara'a is aqdun ala zara' bi ba'd al-kharij. It's a contract to plant in exchange for some of what grows from it. Right? It's often referred to as sharecropping. So what's the scenario? Sidi Hamza, Chaudhry Hamza Khan, right, is a big landowner, right? Now there's a few people who are displaced farmers. All they know is farming. They go to Chaudhry Hamza Khan Saab, and he says, would you hire me? He says, no. I don't pay people to work for me. So what would the aqd be? In muzara'a, say, okay, you work these lands and you have some of the kharij. So what is the earning for working the land? Some of the kharij. There's a problem with it. What's the problem?
Non-specified.
It's no, you say 50% of what comes out. 20% of whatever percentage is. Imam Abu Hanifa didn't like this, right? Because there's a problem with it. If you prepared, you know what the problem is. He says, قال أبو حنيفة رحمه الله تعالى المزارعة بالثلث. Right? So those poor displaced farmers, right? Zainuddin Saab, Umarji, and others, and their families, they said, okay, you work these lands, you get a third of what comes out, or a quarter of what comes out. He says, batila. Right? Right? And it explains. Right? And there's a hadith about it. Naha Rasulullah sallallahu alaihi wasallam anil mukhabara. Right? They differed on the tafsir of, right? And this hadith is related by Bukhari and Muslim. What's the problem with it? لأنها استئجار ببعض الخارج. Right? ولأن الأجر مجهول أو معدوم. What kind of agreement is this? وكل ذلك مفسد. Right? You're agreeing to something that is non-defined, and there's gharar. There's all kinds of problems in it. There's gharar. We don't know if anything's going to come out. So what if they work the whole, whatever, 6 months of the year, and a month before harvest time, there's floods and the whole crop was ruined. But they did the work. Right? وقال أبو يوسف ومحمد هي جائزة. Right? Right? And the fatwa is على قولهما. Right? So theoretically, the position of the Imam is legally more sound in itself. Right? That this type of non-definition corrupts. And you've seen the caution of Imam Abu Hanifa when it comes to definition and non-definition. Right? But most of the books of said the fatwas on there the position of the Sahibain. Why? لتعامل الناس لحاجة الناس وتعاملهم. Because the need of people and their تعامل, right? Right? And they say والقياس يترك بالتعامل كما في الاستثناء. Right? And something can be, and one of the ways to understand that الشيء قد يكون محظورا لنفسه. Something could be interdicted because of itself. This is in itself problematic. أو لغيره, and something could be problematic due to a meaning outside of it. وإن انتفى ذلك الغير مع التعامل يرتفع الحظر. But if that harm, right, so something's not allowed because of a secondary consideration, right? For example, in this case, this non-definition could lead to dispute. It could lead to the denial of their rights, عدم الطلاق, etc. But they say تعامل الناس رافع للنزاع. So the certain jahala does not corrupt the transaction. And we looked at examples of that, right? So this definition gives والقياس يترك بالتعامل, right? يعني في مكان محظورا لغيره, right? And there's different scenarios. We don't need to worry too much about the details of these, right? This used to be a big deal in agrarian societies, of course, right? وهي عندهما على أربعة أوجه. There are 4 types of مزارعة, right? إذا كانت الأرض والبذر لواحد. If the land and the seeds belong to one party. والعمل والبقر من آخر. جازت المزارعة. If the land and the seed, because that's what the crop comes out from, is from one party, and the baqar, the work, and the baqar. And why is the baqar mentioned? What do the baqar do? What do the cows have to do with the land? They plow the land. Good. Right? Because the land and the seeds is what the crop comes from, and it's ijara of amal from the farmer and his cat and his cows or whatever, or other tools. وكذا إذا كانت الأرض لواحد والعمل والبقر والبذر لواحد. And likewise it's valid if the land is for one and the work and the cows and the seeds are from the other. Right? And this is understood that then the worker is, as it were, renting the land. Right? وإذا كانت الأرض والبقر والبذر لواحد والعمل لواحد جاز أو جازت أي المزارعة. If the land and the cow and the seed are for one and just the work are from the other party, this is also valid. But then it's just ijara. Right? Right? Then the owner of the land just rented the worker. Right? Right? So these 3 are valid. Maulana al-Maydani quotes Ibn Abidin, right? Who put these 3 in a line of poetry. وإذا كانت الأرض والبقر لواحد والبذر والعمل لآخر فهي باطلة. But if the land and the cattle, the cows are for one party, the owner, right, the landowner, but the seeds and the work are from the other, then this is batil. Because who is the hiring party? Right? Right, and there's other scenarios mentioned by the commentary in it. And there are conditions for muzara'a to be valid. Right? And this is easily, and there's a wisdom in Abu Hanifa's position besides the legal thing, because this leads to abusive relationships, right? And became a serious problem. وَلَا تَصِحُّ الْمُزَارَعَةُ إِلَّا عَلَى مُدَّةٍ مَعْلُومَةٍ. Sharecropping is only valid for a known period. Right? Like any other, so it's عقد على منافع. Right? It's like hire, so it takes the same of the rulings, right? 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 But the fatwa, according to many books, is that one season is assumed. Right? It's renewed seasonally. Right? And you can see in the Lubab about that, right? But others hesitated, right, about this. ومن شرائطها أن يكون الخارج مشاعا بينهما. From the conditions for this to be valid is that the harvest is proportionately divided between them. فإن شرطا لأحدهما قفزانا مسمى فهي باطلة. But if a specific amount is mentioned for either party, this is invalid. Because then it's not, the meaning of partnership is not in it. وكذلك إن شرطا مع Sorry, I'm having trouble reading today. على الماذيانات والسواقي. Right? And likewise, if they put condition that what's on the madhiyanat, which is plural of madhiyan, which is what's on the on the channels, right? It's a Persian word, right? Was-sawaqi, right? And these are different types of channels. Right? That what grows on the sides of the channels and these are mine, but this is on the, then this also not valid. Right? And there's a few other conditions that you can see that are mentioned in the commentary, that the land has to be fit for growing, etc., but they're kind of obvious. Right? وَإِذَا صَحَّتِ الْمُزَارَعَةِ فَالْخَارِجْ بَيْنَهُمَا عَلَى شَرْطٍ. If in the scenarios where the muzara'a contract is valid, then the crop is divided between them according to the condition. فَلَمْ تَخْرُجْ مِنَ الْأَرْضِ شَيْئًا فَلَا شَيْءَ لِلْعَامِلِ. In this situation, this is what Abu Hanifa was wary about. If nothing comes out, there is no crop, right? Then the worker is owed nothing. وإذا فسدت المزارعة فالخارج لصاحب البذر. If the muzara'a contract was fasid, right, was corrupt, and we've taken the definition between the batil and the fasid, then what the crop belongs to the one who gave the seed, because it grows from it. فإن كان البذر من قبل رب الأرض فللعامل أجر مثله. So if the seed, and if you diagram this, you do yourself some benefit. If the seed is from the owner of the land, then the worker is owed ajrul mithl, because it's as if he was being hired to grow, to work on the growing of these seeds, right? لا يزاد على مقدار ما شرط من الخارج. But they don't go beyond the extent that was agreed upon with respect to the output. وقال محمد له أجر مثله بالغا ما بلغ. Muhammad said he has أجر المثل even if it goes beyond that. And the first position is that of Abu Hanifa and Abu Yusuf, and that is the mu'tamad, right? وإن كان البذر من قبل العامل فلصاحب الأرض أجر مثلها. But if the seed is from the worker, then the owner of the land is owed the ajr al-mithl for the land. Because if you provide the seed, then it's as if you're renting the land. And seed, of course, is a major thing. Right? Even now, seed is highly politicized. So you guys should be familiar with these kinds of things, right? Seed, and that's why the big multinational companies, what used to be called Monsanto, now has been taken over, partially because its name became so toxic. And others, like, some of these seeds, it's like, to be able to use these high yield seeds, they have to agree that they can't regrow the same seeds, etc., because seeds are precious. That's what the crop grows from. Like, seeds aren't just a small thing. وإذا عقدت المزارعة فامتنع صاحب البذر من العمل. If the muzara'a is enacted, right, with the conditions, and the one who provides the seed refuses to act, لم يجبر عليه, you refuse to work, and this is before planting the seeds. This is an important condition, right? قبل إلقاء البذر, before planting the seeds, because before it, it's not a binding contract, right? Till then. And they give a few examples, right? Right? This is لم يجبر عليه. وإن امتنع, and if he refuses, الذي ليس من قبله البذر أجبره الحاكم على العمل. But if the one who is not providing the seed refuses to work, and they entered into the contract, they're forced to, because it's a binding contract. Because there's no harm for them to fulfill their part of the agreement. وإذا مات أحد المتعاقدين بطلت المزارعة. If either transacting party dies, the muzara'a contract ends, just like ijara. وإن قضت مدة المزارعة والزرع لم يدرك كان على المزارع أجر مثل نصيبه من الأرض إلى أن يستحصد. Right? So if the period agreed upon for the muzara'a contract ends, but the crop hasn't yet ripened, then the muzari', the farmer who's working the land, has the right to ajr al-mithl, to the market value of their labor, ajru mithli nasibihi min al-ard, right? The market value of the land, until it bears, until it's ready for harvesting. وَالنَّفَقَ عَلَى الزَّرْعِ. So who has to pay for the cost of zara'? عَلَيْهِمَا is upon both of them. عَلَى مِقْدَارِ حُقُوقِهِمَا, in accordance with how much right they have to what grows. وَأُجْرَةُ الْحَصَادِ, and the cost of harvesting. وَالرِّفَاعِ, right? And of transporting it from the land, from the land. وَالدِّيَاسِ, and then to sift it. وَالتَّذْرِيَةِ, right? And to sift, to sort through it. عَلَيْهِمَا بِالْحِصَصِ, is shared between them according to their shares. فَإِنْ شَرَطَاهُ عَلَى الْعَامِلِ فَسَدَتْ. But if they make it a condition upon the one working, the muzara'a is fasida, because it's not a condition entailed by the contract, right? 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 in the Tasheeh, it mentions that this is Zahir al-Riwayah, right? But Al-Husam al-Shaheed said in Al-Kubra, Fatawa Al-Kubra, وعن الحسن عن أبي حنيفة is جائز, right? وهكذا عن أبي يوسف قال في الهداية, right, that this would be allowed if this is, you know, this would be allowed like under istihsan, and a lot of the ulama took it because also this was a ta'amul, right? And this also chosen by Mashayikh Balkh, who were quite interesting for many reasons, and a whole bunch of people, right? And that goes back to the issue of ta'amul as well. And here, of course, there's a classical moment in the dars. Omar, if you want to come see it, there's a classical moment. So here, at this expression, al-khata' inda Shaykh Adib, right? So what happened here? This says قال في مختارات النوازل هو اختيار مشايخ بلخ وبخارى. So there's a few, because there are a few mashayikh, so these brothers were terrible students. Oh my God. So one of them was insisted on reading. Shaykh Adib didn't like people to read in his lesson because he didn't like grammatical mistakes. So they read this, هو اختيار مشايخ خراسان. Shaykh Adib winced. And then he says, هو اختيار, there's a few of these مشايخ, اختيار مشايخ بلخ, اختيار مشايخ بلخ. Then مشايخ, اختيار مشايخ خراسان. Then read, اختيار مشايخ العراق. That's what Shaykh Adib said. يا ابني, قرأت من النحو شيء? Have you read any نحو? Says اختيار ماذا هو? He asked him. Says والمضاف إليه يكون ماذا? And they had no clue. Like he sounded like he was speaking a different language. And Shaykh Adib rarely got upset with students, but he was very, اختيار مشايخ بلخ وبخارى. And the point is, if the harvesting and the sorting, etc., were specified for the amil, the Zahir riwayah is that then the meaning of sharika is lifted from the muzara'a, but the second opinion allowed it, and because of ta'amul. Now musaqa is similar, and it's also called mu'amala. Imam Abu Hanifa also didn't agree with it. قال أبو يوسف قال أبو حنيفة المساقات جائزة. Right? What is musaqa? Right? It's mufa'ala, this active engaging in saqi. شرعا دفع الشجر إلى من يصلحه بجزء من ثمنه. Right? So someone has an orchard. They have trees. Say, okay, you cultivate these trees, take care of them, and you get a portion of what grows from it. And musaqa, because a lot of their effort, if you have of an orchard, there's trees, etc., is to water them, irrigate them, etc. Right? And as the commentator said, هي كالمزارعة حكما. It follows the same rulings as مزارعة وخلافا, and in its difference and in its شروط. قال الإمام أبو حنيفة المساقات بجزء من الثمرة باطلة. Right? مساقة, right? Which is tending to trees for a share of the crop, is باطلة, but الفتوى على قولهما. The fatwa is on the position of Abu Yusuf and Muhammad. إذا ذكرا مدة معلومة. It says if they mention a known period, meaning ولو, right? And then وقال وَسَمَّيَا جُزْءًا, and they mention a share. مِنَ الثَّمَرَةِ مُشَاعًا, if they mention a portion of the thamara, of the fruit. وَتَجُوزُ الْمُسَاقَ, so عفوا, وقال, I have something missing in my commentary. Sorry, وقال جائزة, and the two Sahibain said it's valid إذا ذكرا مدة معلومة, if they mention a known period. وسميا جزءا, and they mention a juz, a share, من الثمرة مشاعا, right? A non-defined share, a quarter, a third, 50%, 60%. So that has a meaning of sharika. وتجوز المساقاة في النخل والشجر والكرم والرطاب. Right? So musaqa is allowed in, what's nakhl? What's nakhl, folks?
Date palm?
Yeah, in date trees and grapes and ritab is growth that is still moist, because that like grasses and stuff that are harvested, right? Right? And likewise, all types of buqul, like all kinds of of harvested crops, right? فإن دفع نخلا فيه ثمرة مساقاة والثمرة تزيد بالعمل, right? Then jaz. So what if the owner gave some trees that have fruit already in a musaqa contract, and the fruit would be increased in value by the work? This is valid, right? Right? COVID happened, all the farm workers left. So convinced, okay, look, please finish the work on the farm. I'll give you 25% of what grows. And there's still time, it'll increase in value, this would be valid. وَإِنْ كَانَتْ قَدْ انْتَهَتْ, but if the fruit has finished ripening, it's not valid, right? Because it resembles ijar in one sense, and ijara is upon amal, and there's no amal. It's done. It's ready. All we have to do is to pluck it now, right? وإذا فسدت المساقاة فللعامل أجر مثله. And if the musaqa is fasid, then the worker has the أجر المثل. وتبطل المساقاة بالموت. And musaqa is invalidated upon death. وتفسخ بالأعذار. And it's invalidated through excuses. This applies to musaqa and muzara'a. كما تفسخ الإجارة. Just as ijara contracts can be annulled with legitimate excuses. Okay? And there's some details that are mentioned in the commentary that are useful. With that, bihamdillahi subhanahu wa ta'ala, we finished the section on mu'amalat. So we finished personal law, and we finished mu'amalat, and we switched the order as you may have been aware of. We ask Allah subhanahu wa ta'ala أن يلهمنا العمل بعدل وإحسان بكل ما جاء به سيدنا محمد سيد ولد عدنان، وأن يلهمنا الإخلاص والسداد، وأن يلهمنا حفظ العلم بحسن التكرار وحسن التفهم وحسن المدارسة بفضله ومنه وتوفيقه. وصلي وسلم وبارك على سيدنا محمد وعلى آله وحسبه والحمد لله رب العالمين. Sorry, those sections are of less practical. Never answered anyone's muzara'a question yet, right? But they exist, and the thing is, we have to realize that we should be hopeful for a time when people are acting on the deen more seriously, Open any books of fatawa. How much of the book of fatawa is on the fiqh of worship? Some of them it's only a page or two. And the rest of the book, hundreds of pages, is in the other chapters. Because people are supposed to be living their deen, in living the divine guidance in every aspect of their lives. Rental is every human relationship is a series of contracts. And all of this has to be taken seriously. And that sort of should be the asl in the lives of the believers. وصلى الله على سيدنا محمد وعلى آله وصحبه وسلم. You stopped?